guys.
This is a court of appeal case between the appellant Andrew Abraham and the Moon newspaper Berhad and the respondent Michael Rotter. Lead counsel appellant, you may begin your submission.
May it please this honorable court, I'm Derek Tong King Sen and I appeal for the appellant Andrew Abraham and the Moon newspaper Berhad in this section, together with my learned co-counsel, Mr. Nigel Law Kaiser. Appealing for the respondent, Ms. Su Jing and Ms. Lin Xiang Yi. There are two grounds for the appeal. I will address ground 1 and my learned co-counsel will address ground 2. My lady, the appellant humbly submits that the trial judge had erred in admitting the first defendant's WhatsApp message stating, "I will not apologize until I get my money" as an admission of liability for defamation. My lady, under Section 17 Sub 1 of the Evidence Act, an admission must suggest an inference as to any fact in issue. The fact in issue in this case is whether the appellants published false and malicious statements. As established in Kawan Lama Builders Berhad and another, and Syarikat Lumut Quarry Berhad, for a court to act on an admission, it must be unequivocal, clear, unambiguous, and relate directly to the subject matter. The appellant submits that the WhatsApp message does not suggest such an inference. It is merely a conditional refusal, not a concession of legal wrongdoing. It relates to a pre-existing financial dispute, which is the unpaid cost of 29,414 ringgit 38 cents from the first defamation case. It is therefore legally unsound to interpret a refusal to act until a debt is paid as an admission of libel. Even if this court were to find the statement relevant, it should have been excluded under Section 23 of the Evidence Act, which provides that in civil cases, no admission is relevant if made under circumstances where the court can infer that the parties agreed the evidence should not be given. My lady, the context here is critical. This message was sent immediately after the respondent issued a legal notice demanding an apology. This initiated a period of negotiation aimed at resolving the dispute. According to the test in Malayan Banking and Fu Simoy, the without prejudice protection applies when the parties are in negotiation and there are terms to settle the dispute. The exchange of an apology for the payment of debt is clearly a term of settlement. Further, the House of Lords in Rush and Tompkins Limited and Greater London Council held that the application of the without prejudice rule is not dependent on the specific phrase without prejudice. If it is clear from surrounding circumstances that parties were seeking a compromise, the evidence is inadmissible. The public policy behind Section 23 of the Evidence Act is to encourage settlement and negotiation without the fear that every statement will be used as a sword in the court. By admitting this message, the trial judge has punished the appellants for attempting to resolve a long-standing feud outside the court.
Counsel, isn't this message just an opening shot rather than a genuine negotiation, making it admissible as per Boss Ramasamy and Penang Port case?
With respect, my lady, this was not an opening shot. In Boss Ramasamy case, the letter was excluded from protection because no actual negotiation had begun. In this case, the respondent had already issued a formal demand, and the appellant's response was a specific counter-proposal regarding the terms under which he would consider an apology. This represents the course of negotiations aimed at reaching a settlement. To admit such complications would undermine the public policy of encouraging parties to settle their dispute out of court. My lady, for the above-mentioned reasons, the appellant humbly prays that the appeal on ground 1 is allowed with cause. Unless I can be of any further assistance to your lordship, this concludes my submission. Much obliged, my lady.
Co-counsel appellant, you may begin your submission.
May it please this honorable court, I am Nigel Law Kaiser, co-counsel for the appellant. I will now address the second ground of appeal that the learned trial judge erred in law by excluding evidence of the respondent's prior criminal conviction, thereby failing to recognize that the respondent is entitled liable proof. My lady, the trial judge excluded the respondent's prior criminal conviction by ruling that he ran foul of the general rule against character evidence under Section 52 of the Evidence Act 1950. Section 52 only prevents character evidence from being used to prove liability. However, this ground of appeal concerns the assessment of damages. Section 55 states that in civil cases, the fact that the character of any person is charged as to affect the amount of damages which they ought to receive is relevant. However, evidence can only be given of a person's general reputation and not of particular acts. In Harmanchan Singh and State of Punjab, reputation is defined as a definite and final formation of opinion by the community. A national video scandal is not a mere particular act. It will define a political's general reputation in the eyes of the community.
Counsel, the explanation to Section 55 explicitly bars particular acts. Are you not asking this court to simply relabel a particular act as general reputation in order to circumvent the explanation?
No, my lady, we are not just changing the label. We agree the rules strictly ban looking at the act itself, but we are looking at the result of the act. Because this scandal was all over the news, this completely destroyed his public image. His reputation is ruined, so Section 55 of Evidence Act allows us to show the court what his true reputation is. With your ladyship permission, I shall now continue with my submission. Section 12 mandates that any fact enabling the court to determine damages is relevant. This evidence is strictly admissible. Therefore, it is clear that the trial judge was legally obligated to consider the existing state of the respondent's reputation. My lady, we acknowledge the High Court in Dato Seri Ahmad Ibrahim and Khairi Jamaluddin stated that there is no defense of a libel proof under Malaysian law. However, in the exact same judgment, the court expressly affirmed that a ruined reputation must be considered for the purpose of determining quantum. My lady, the underlying principle of damages in defamation is purely compensatory, not punitive. A plaintiff cannot be compensated for a pristine reputation he does not possess in reality. I direct this court's attention to the landmark High Court decision in Sanderson and Malaysians Unlimited. Justice Ong, in reducing the defamation damages to a mere 1 cent, famously ruled that the plaintiff's prior misconduct had left it with, and I quote, little residue of credit and reputation to be further damaged by the libel. We urge this court to apply the Sanderson principle today. The respondent is a leading political and public figure. His standing in the eyes of the Malaysian public was already severely compromised by a highly publicized criminal conviction involving a pornographic video scandal. By excluding this evidence, the trial judge assessed damages in a vacuum. Awarding a total damages of 700,000 against an appellant to a man whose public standing was already in ruins is not compensation, it is unjust enrichment. Therefore, we pray that this court allow the appeal on the second ground, and leave the evidence of the respondent's pre-existing character to reflect the reality of his reputation. Unless I can provide further assistance to your ladyship, those are my submissions for the appearance. Much obliged, my lady.
Lead counsel respondent, you may begin your submission.
May it please this honourable court, my name is Su Jingyu and I appeal for the respondent Michael Reuter in this action, together with my learned court counsel, Ms. Ling Xiang Yi. The respondent humbly submit that the learned judge was correct in ruling that the first defendant's WhatsApp message to be admitted as an admission of liability, as it indicated that an apology will be issued once the new check was received. My lady, the statement certifies the strict statutory definition of admission under Section 17 sub 1 of Evidence Act, which suggests any inference as to any fact in issue or relevant fact. Section 21 of Evidence Act also states that admissions are relevant and may be proved against the person who made them. According to Ananda Gowda against R, the test for determining whether a statement is a confession is an objective test based on reasonable man reading the statement.
Counsel, your objective test is based on Ananda Gowda against R. However, Ananda Gowda is a criminal case that only deals with murder confession. We are currently engaged in a civil defamation appeal. Why should a civil admission be subject to a criminal standard in this court?
With respect, my lady, even though Ananda Gowda is a criminal case, but the rule also applies to civil case. Since confession is a type of admission, the law treats the same when interpreting whether a statement amounts to inference. The same logical framework applies. My lady, in this case, applying the objective test, the statement "I will not apologize until I get my money" immediately after the respondent demanding a retraction and apology. An ordinary man reading this test would conclude that the first appellant is not denying his fault, but treating this apology as a bargaining chip to secure his previous court costs. Therefore, the statement suggests a clear inference of fault under Section 70 sub 1 of the Evidence Act. Since it is an admission made by the appellant, the respondent is fully entitled to prove it against him under Section 31 of the Evidence Act. Furthermore, Sepang International Secure Sdn Bhd and M7 Racing Sdn Bhd state that admission did not fall under Section 23 as it did not indicate that its content were made without prejudice, either expressly or impliedly, for such correspondent to be excluded as evidence. Hence, the admission amounts to estoppel on the part of defendant from denying the plaintiff claim. Hence, applying to the current situation, there is nothing indicate that the message between the first appellant and the respondent is made without prejudice. My lady, the first appellant used the statement to demand the payment of court costs does not amount to mutual negotiation. The facts show there was absolutely nothing left to negotiate. On February 16 of 2024, the appealant's office manager had already agreed to wait for the replacement check, which was already in transit. Therefore, WhatsApp message sent 3 days later was not a mutual compromise over a debt. He was not trying to settle a disputed debt by using a fresh defamatory wrong to issue a harsh demand of money. According to Boss Ramasani, Section 23 of Evidence Act cannot apply if it is merely an opening shot. Applying back to the current situation, the letter of demand sent by the respondent is a unilateral demand for legal redress. The WhatsApp message following the letter of demand is a counter demand for money, which qualified as an opening shot. It is a preliminary communication before any actual negotiation process can begin. For this reason, the respondent prayed that this ground of appeal be dismissed. My co-counsel, Ling Xiangli, will now address the second ground of appeal. Unless I can be of any further assistance to your ladyship, this concludes my submission. Much obliged, my lady.
Co-counsel respondent, you may begin your submission.
May it please this honorable court, I am Ling Xiangli, co-counsel for the respondent. I will address the second ground of appeal. My lady, the appellant relied on Section 55 of the Evidence Act, which provides that character is relevant to the assessment of damages. However, the explanation to Section 55 is unambiguous. Evidence may be given only of general reputation and general disposition and not of particular acts. A prior criminal conviction is, by its very nature, a particular act. It cannot be dressed up as general character evidence. This was affirmed in DP Vijandran and Kapasing, a defamation case on nearly identical facts, where the defendant sought to tender a court of appeal judgment to show the plaintiff bad character in mitigation of damages. The court held that only general evidence of character may be adduced under Section 55. Specific convictions and particular acts are strictly inadmissible. This principle was further reinforced by the Court of Appeal in Dato' S. Nala Karapan and Dato' Seri Anwar Ibrahim, where the court made clear that relying on a criminal conviction to establish bad character in a civil defamation suit is impermissible, and that the explanation to Section 55 admits of no exception for particular acts. Furthermore, my lady, the judgment which the appellants seek to admit is also barred by Section 43 of the Evidence Act. Section 43 states that judgment from other proceedings are irrelevant unless the existence of that judgment is itself a fact issue.
Counsel, if the judgment is tendered to show what was publicly known about the respondent's reputation at the time of publication, does Section 43 still operate as a bar?
With respect, my lady, the framing does not change the substance. The appellants are seeking to use the findings within the Court of Appeal judgment specifically. The finding that the respondent was the male actor in the video as proof of fact in these proceedings, that is precisely what Section 43 prohibits. As affirmed in the recent case of John Until and others and Prolific Yao, a party cannot rely solely on a previous conviction or judgment. Independent evidence must be produced. If the appellants wish to establish the respondent's bad reputation, they must call witnesses to testify as to his general standing in the community. As for the doctrine of libel proof, the case of Dato' Seri Anwar Ibrahim and Khairi Jamaluddin is instructive. The court expressly rejected it as an American doctrine with no application in Malaysian law. There is simply no basis to import it here. My lady, we respectfully urge this court to dismiss the appeal and affirm the decision of the learned trial judge. Unless I can be any further assistance to your ladyship, this concludes my submission. Much obliged.
Having considered the submissions of the counsel on both grounds of appeal, this court is satisfied that no reversible error of law has been shown. On the first ground, Section 23 does not apply. There was no express without prejudice label, no mutual agreement, and what transpired was merely a unilateral demand, not a genuine negotiation. The WhatsApp message is admissible under Section 17 sub 1 and Section 21. The trial judge was correct. On the second ground, the explanation to Section 55 clearly bars particular acts. A prior convictions cannot be repackaged as general reputation evidence. It is further barred under Section 43 of the EA. The libel proof doctrine has no place in Malaysian law. The second ground of appeal is dismissed. The High Court did not misdirect itself in law or principle. The appeal is hereby dismissed.